Welcome, class, to Jake and Carson's AP Gov Supreme Court Cases presentation.
Today, me and Jake will be discussing three classic court cases having to deal with freedom of press. These cases involve New York Times versus Sullivan, New York Times versus the United States, and Neer versus Minnesota. Well, class, I hope you're able to learn about these cases and enjoy our presentation. Thank you. The first case we will be talking about today is New York Times versus Sullivan. In 1964, the New York Times posted an article defending Martin Luther King Jr. that contained false information, and although it did not mention him by name, Sullivan sued for libel. The state court ruled in favor of Sullivan due to Alabama's libel action law, giving him $500,000, and later the state Supreme Court confirmed the decision. As a result, the New York Times appealed to the Supreme Court of the United States. New York Times versus Sullivan, petitioned by the New York Times, arguing they should not have to pay libel for the presented offense, and Sullivan, Alabama's public safety commissioner, arguing the Times should have to pay for libel for the false information. In the case of New York Times versus Sullivan, the case had appellate jurisdiction. It began in a state court where it was eventually affirmed by Alabama State Supreme Court. Due to the appeal filed by the New York Times, it was sent to the Supreme Court of the United States. The constitutional issue with this case is that it presented the question on whether or not Alabama's libel action law violated the First Amendment, protecting freedom of speech and press. The ruling in this case was that in order to obtain libel, the author of the information had to originally know the information was false and publish it out of spite. This was not the case for the New York Times. The Supreme Court had a unanimous decision. All on the court agreed to this ruling in favor of the New York Times. Justice Brenner presented the ruling. Lastly, the importance with New York Times versus Sullivan was that this case reaffirmed the protections under the First Amendment of the U.S. Constitution. It established the ruling that a state cannot enforce a libel action law unless the petitioner, in this case Sullivan, could prove that the author of such an article published it out of malice or spite, meaning they originally knew the information was false and published it out of recklessness.
The second case that involves the freedom of the press is New York Times versus United States. This is also known as the Pentagon Papers case. President Nixon and his administration wanted to prevent the New York Times from publishing papers from the Department of Defense detailing their efforts in Vietnam. They argued this was vital to protect national security. New York Times versus the United States, petitioned by the New York Times, wanting to publish these documents, and the United States Nixon administration wanting to prevent these cases from being published. The case had original jurisdiction to the Supreme Court due to the fact it was the current president's administration trying to prevent these documents from being published. The constitutional issue was the case raised the issue of whether or not Nixon's administration violated the First Amendment by trying to prevent these documents from being published. The ruling was the court held a 6-3 decision issued by Justice Black that the administrator's efforts to prevent these documents from being published did violate the First Amendment because it was up to the press to check the actions of the government. This opinion was issued by Black, concurred by Brennan, Stewart, White, Douglas, and Marshall. The dissenting opinion was from Berger, Harlan, and Blackmun. The importance of this case was it established the protection of the press from the federal government. The federal government is not to violate the First Amendment by preventing the press from allowing the public to know what is going on.
Our third and final court case involving freedom of press involves Neer versus Minnesota, happening in the years of 1930 and 1931. J. Neer, in a Minneapolis newspaper, wrote an article accusing public officials of being involved in gang activity. Minnesota officials wanted to issue a permanent injunction on the newspaper, stating it violated the public nuisance law. This law, if violated, resulted in injunctions on those that published malicious or scandalous information. Neer versus Minnesota, petitioned by J. Neer, accused of violating the public nuisance law and had injunctions issued against him, was going against the state of Minnesota in court, who wanted to establish permanent injunctions of the newspaper. Just like our first case of New York Times versus Sullivan, Neer versus Minnesota had appellate jurisdiction as it started in trial court where the injunction was established and then went to the state Supreme Court. It eventually made its way to the Supreme Court of the United States.
The constitutional issue in the Neer versus Minnesota case was the case raised the question of whether the Minnesota public nuisance law violated the freedom of press portion of the First Amendment. In the ruling of Neer versus Minnesota in a 5-4 decision, the Supreme Court ruled in favor of Neer, saying the government could not censor a publication in advance to it being published, and that the way the nuisance law was applied to this case was unconstitutional. The ruling was presented by Justice Hughes, concurred by Holmes, Brandis, Stone, and Roberts. Dissenting opinion consisted of Devanter, McReynolds, Sutherland, and Butler. The importance of Neer versus Minnesota was the case upheld the First Amendment's portion referring to freedom of the press. It establishes the fact that the government cannot censor information that has not yet been published. Out of all three of these cases involving freedom of the press, they all had important issues that needed to be solved. And out of the three, the issues discussed will always have an important place in the government and the law. With all of these three cases, the First Amendment was discussed, which is one of the most important amendments in the Constitution. The First Amendment is important because it allows people to express their opinions, but depending on what it is, the consequences can be immense.